talking about today is the IPP. Now, your audience, Shannon, is probably very familiar with the IEP process. And there are a lot more attorneys that work on that side than they do the regional center side, and there are reasons for that I'm not going to get into. But the IPP is a plan for the regional center consumer that talks about the supports and services that regional center and other generic resources and parents are going to provide for the consumer. In contradistinction to the IPP only needs to be redrafted once every 3 years, which is odd, although that's often not followed. But the IPP meeting is held usually at least once a year and sometimes more often. So the regional center will pick a date for a meeting, and then you will want to write them a letter that says you intend to audio record the meeting, because they are entitled to at least 24 hours notice, and you should always avail yourself of the opportunity to preserve what is said in the meeting. And then you get into a question about venue, because the regional center service coordinators like to come to the consumer's house to have the meeting. And the reasons for that include the fact that the consumer is there and they can combine their quarterly or annual visit, whatever it is, where they see the consumer with doing the IPP meeting. I don't have a hard and fast rule on this, but in some situations, I mean, it's kind of feels a little bit more, shuck and jive, unprofessional to do the meeting in somebody's home. Maybe it's a little less intimidating to the regional center. So I have been known to insist that we do the meeting sometimes in the regional center office. It's going to be a case by case or a meeting by meeting determination. But anyway, you're going to get together and you're going to have a team there. It may or may not include the regional center psychologist. It probably will be the service, certainly will be your service coordinator and, possibly other people who are providing the service. So I guess it's worth saying a word about the service coordinator, even though it's seems as if it ought to be obvious. I don't necessarily think it is. Service coordinators are usually social workers, not always, and their role is supposed to be, if you read the Lanterman Act carefully, they're supposed to advocate for the consumer as against the larger system. People don't know that because many, many service coordinators are protecting the bottom line and they behave like gatekeepers. But your regional center service coordinator or your child ought to be an advocate for your child. And if you don't feel that that's what you're getting, then you need to change service coordinators, which the Lanterman Act is much more permissive about. The school district, pretty hard to change up personnel. You don't really have the right to do it usually. But with the Lanterman Act, you do. And I learned this in an odd way, which was I had a service coordinator who followed another one. Sometimes they change, the cases shift around. And I love her to this day. I don't know if she's alive or not anymore. I hope she is, because she kind of disappeared all of a sudden. I was concerned that maybe something bad happened. This was when my child was very young. But she set up a meeting with me, and she came over, and she said to me, "What do you think we need to get for your kid? I'm here to serve you." And she told me about a lot of stuff. It wasn't like I had to say, well, do you have this or this or this? She was like, well, would he like a computer? Would he like a recreational program in a gym? She went down the list and I was like, wow. And then she got it approved. And that is really what the service coordinator is supposed to do. But I would say that with regional center, many of them have never read the Lanterman Act and they haven't necessarily been properly taught by upper management. So they don't necessarily know this, and a lot of the time they give you pushback. But a service coordinator is supposed to coordinate the delivery of services, which is what the Lanterman Act is all about, supports and services. So you go to your meeting and you have your list of non-educational things that your child, the consumer, needs, and the service coordinator is supposed to work with you to get those services approved and to coordinate them. And that's a little different view, I think, than a lot of us might have coming away from a meeting where it seems like there's an awful lot of paperwork and verbiage and not much is accomplished. But that is what the service coordinator's role is supposed to be. And this meeting is a meeting where you are supposed to develop the regional center equivalent of goals. They're called outcomes. And so they're supposed to be written into the IPP. And as with your IEP, if you end up in hearing and you're arguing that the regional center isn't doing something that it's supposed to be doing, one of the things the administrative law judge is going to look at is, was this written into the IPP? So, sometimes they offer stuff in a letter and they don't memorialize it, and you really want to get a written memorialization of the meeting. At that meeting, you have to prepare in order to make your case for what you want. So typically the parent historically has wanted behavior intervention services. There are other things too that you can ask for, but that's maybe less true now with insurance. But some people don't have a policy that actually includes autism treatment. So if you're one of those parents, you're going to go to the IPP meeting and you're going to make the case for the number of, why the service is necessary in the first place if there isn't agreement that it is. And then second of all, what is your justification for the service? And typically, you're going to need an outside professional to justify the number of hours, whether that's the behavior vendor, which is a little dicier because they're subject to being, accused of having a conflict of interest since they're going to provide the service, and so more is more. It could be an outside psychologist. And in the best case scenario, you're going to have that person come to the meeting so they can speak to the issues, be recorded, have the regional center hear. The regional center is going to size the person up, see how knowledgeable they are, see what kind of witness they would make, and then they're going to consider the evidence and decide whether or not to give you what you ask for. If they do give you what you ask for, they are required to prepare the IPP document and get it to you. They say within 15 days, but my read of the Lanterman Act is 5 days. But, just 15 days at the outside, you're supposed to come away with a written memorialization of your meeting. And then if you disagree, there are things you can do, because there is an appeal process in the Lanterman Act, and it starts with what they call an informal conference. And that's basically not likely to lead too much, because it's kind of like a review by a higher management person in the regional center. If that doesn't work, they offer mediation with an administrative law judge, and that can be pursued, and sometimes it's very effective. But I guess what I should have said before all of this is you don't get any of those appeal opportunities unless you appeal the decision of the regional center team about what services the consumer is entitled to. We know that IDEA in California has a 2-year statute of limitations. That's a long statute of limitations relative to what you have with the regional center. With the regional center, you have only 30 days to appeal, and if you don't appeal within that time, you lose the right to appeal. So if you appeal, it's not difficult. It's basically, there's a form, a 2-page form or something that you get online at the DDS website, and they ask you, what is the nature of your problem and what would be required to solve your problem. So it's like, my son needs intensive behavior intervention for X, Y, and Z reasons, and I need, what would solve the problem? I need 20 hours a week plus, 8 hours a month supervision. And so that's something that can easily be filed by the parent. That will get the Office of Administrative Hearings involved, and they're the ones that will, first of all, set up the mediation with the regional center, setting up the informal conference. And then if you actually still don't reach agreement after mediation, you will go to hearing. And those hearings are very interesting because in distinction, in contradistinction to IDEA, where the parent has the burden of proving that the district's offer was inappropriate, in these Lanterman cases, you actually have the burden of proving that the regional center isn't maximizing the child's likelihood to live independently as an adult. And for some reason I've never been entirely clear on, regional center goes first, whereas in the IDEA hearings, the school district cases, the parent goes first. And it's really quite valuable to go second because you can see what the evidence is and you can be using all that time to prepare your response to that evidence. So that's one really great thing about regional center hearings. The other great thing is they're hard to lose because you're asking for maximization and you're entitled to it under the statute. And if the regional center can't show that they're maximizing, the administrative law judge is likely to fine for the consumer. Whereas in the school district cases, all they have, this is being reconsidered by the Supreme Court right now in the Andrews case, but heretofore, the parent has had the burden of showing that the district's offer free appropriate public education didn't offer some benefit. It's like a C standard. So anyway, we could have a whole separate discussion, because I'm not sure where we are time-wise, on actually how you would prepare for a regional center hearing. So what I want to say about that, and then Shannon, you can tell me where we are on time, is that the regional centers are supposed to have advocates to help parents with this. Some of them will actually farm you out to a lawyer. Some of them will just give you like a client rights advocate that'll give you some pointers. But they do have those people, and it's important that you know that. The other thing I wanted to say, as long as we were talking about statute of limitations, is once you have the services written into an IPP, if the regional center wants to take them away, they have to give you written notice, usually by certified mail. And here there's another important statute of limitations that comes into play, and that is this. If you had your 20 hours of ABA a week plus 8 hours a month of supervision and they decided it was no longer necessary, then what would happen is they would send you this written notice that I described. And the notice will tell you about your appeal rights, but they're usually on the back or it's kind of oblique and not that clear. You have 30 days to appeal the decision. However, if you want to continue your services, aid paid pending, there's a much shorter statute of limitations. You have only 10 business days to appeal that decision. So you have to file very quickly, and countless people have lost their services because they were not aware of what the statute of limitations was. So be clear, regional center determinations of any sort have very short statutes of limitations, 10 and 30 days respectively. So should I stop there, Shannon?
I think that's a good place to stop, unfortunately, because we've got some guests. But I was not aware of that, Bonnie. So 10 days, because we're getting more and more people who are letting us know that whether it's insurance or regional center, that after a certain age they're being told, oh nope, your child is done with ABA. We only fund ABA up until this arbitrary age, and it's different for different regional centers. So they only have 10 days to appeal that.
And arbitrary is the right word because there's nothing in the Lanterman Act that says that. As long as the services are maximizing the consumer's ability to live, to approximate the normal manner of living of ordinary people, which is what the language in the statute says, the service is still something which should be paid for, unless you can get it from what they call a generic resource, which would be the school district or some other public agency or private insurance.
And so for when you say, okay, you've got 10 days to file, I think we all panic because we don't know what that entails. But is it really at that point, that's when you pick up the phone and you call for legal support? Or is there a way for parents to file themselves?
Well, there's definitely a way for parents to file themselves. There's also a way to have parents use an attorney as a coach rather than do the whole hearing, help them prepare for the hearing, because hearings can be expensive and there's no attorney fee reimbursement, which is a real downside to the Lanterman Act. But the form that I described, the 2-page form, is your appeal form. I could get one of those forms ready to go in 5 minutes. Okay. It's not substantive. It's not like you do process hearing requests on the school district side. It's just what's the nature of your problem and what would be required to solve it.